Hello, welcome back. This is Roger Royce with the 10,000 Startups podcast. I'm a lawyer with Haynes Boone in Palo Alto, California. I do emerging growth and venture capital. And today I want to talk about a case that is pending in federal district court in Oakland right now. It's called Musk v. Altman for short. And you might be wondering why this is worth a podcast. People sue each other all the time. So who cares about what looks like a fairly petty dispute among a couple of billionaires? But there is real significance to this case and some very interesting issues that a lot of corporate lawyers like me are watching fairly carefully out of mostly intellectual interest, but also how it might impact how we do things going forward. So let me unpack this a little bit. I've talked about this case before, but for those of you that might not have heard my prior podcasts, this is really a case that's going to raise questions about how nonprofits interact with capital markets, what happens when they spin off for profits, whether mission driven nonprofits can pivot to a for profit structure, and all the issues around that. Now, why this is significant is that we do this all the time. We have a nonprofit, they suddenly realize that, oh, we got something people will pay for here. Let's spin that off into a for-profit, get some financing together, find some founders, put in place the proper safeguards, and take the for-profit forward. Like I say, I've been doing that for 40 years. I've seen that all the time. And what's different about this case, you might ask? Well, let me tell you. Maybe you'll determine nothing, but actually, let me tell you what's different. So, first of all, the case has two kind of broad, well, it's been narrowed to two claims. One is this concept of breach of charitable trust. And there's California law on this, and the other is an unjust enrichment. And you'll find breach of contract language throughout. I don't care about that. That's all factual. It's he said, she said. I'm mostly concerned about these two claims, the breach of charitable trust and the unjust enrichment. And it's interesting that the damages that are being asked for, it's not that Elon doesn't have enough money and wants more money from this entity. He wants those profits from the nonprofit to be disgorged and basically unwound and go back to the nonprofit model effectively. So there's some precedent for that sort of thing. So let me start with that. Many years ago, Blue Cross Blue Shield, some of you might remember this, they switched their they switched their structure from a nonprofit structure to a for-profit structure. It was a different way they went about it, but essentially that's what happened. They went from nonprofit to for-profit, just like it is alleged that OpenAI did. State of California, the Attorney General actually brought suit and said, "Look, you're taking charitable assets and you're converting them to a for-profit business. And on this charitable trust principle, the state of California, the California Attorney General, argued that those nonprofit assets have to be used for their intended purpose, or that is a breach of the charitable trust. And they would have to be transferred to, if you can't be a charity anymore, you got to transfer those assets to another charity. So that was a basic claim. And honestly, I don't recall exactly how it ended up. I know that there was a huge payment by the Blue Cross entities to some newly created or maybe existing charities that could enforce the original charitable purpose. Okay, so I told you that to tell you this. That's the background. So there is some precedent in the law for that sort of thing. Now, against that background, you're probably wondering, well, why did I say we do this all the time then? How is this possible? Well, here's an example. You got a university that commercializes IP through a startup. You have a hospital that operates a for-profit affiliate. You have a foundation that wants to invest through a mission-related entity, and we do that. And the difference is a couple of things. Number one, this case allegedly the for-profit just really dwarfs the nonprofit. It's become so much bigger in economic value, content, and control. And it's the primary engine of this wealth creation here. So it's just not a minor commercial arm. It is essentially, and this is what is at issue here, an inversion. Now, I know that the Altman side is saying, not an inversion. We just created a nonprofit or a for-profit, and most of that stock continues to be owned by the nonprofit. So this is going to be an interesting case as to whether that's significant or not. So the theory is not just that you created a for-profit subsidiary. It's a couple of things. Most significant for my purposes is this charitable trust obligation, this charitable asset obligation, that those assets are so valuable. Our mission is charitable. You have to devote those assets to that mission. Now, like I say, there's a contract claim in here too, because there's also the you promise not to, and that's completely factual. So I'm going to leave that aside and just focus on this legal issue. Now, in a traditional nonprofit structure, the nonprofit retains control. Profits get recycled into their mission activity. But here the allegation is that control is shifted to the for-profit, and the economic upside is accruing disproportionately to management, employees, and investors, as well as other constituents. And that gets right to the heart of nonprofit law, because the allegation is that that is private inurement. And those are the words that you that you hear a lot in this area, and you absolutely have to avoid private inurement. That means some individual is going to benefit from the nonprofit's activities, and benefit by more than just the usual arm's length. If the nonprofit hires a lawyer, the lawyer is benefiting, right? But more than that, there's private inurement to certain individuals. Now, getting back to this claim, breach of charitable trust, because that's what this case is going to be decided on. It's not going to be decided on private inurement. And the theory is that the nonprofit is subject to this charitable purpose constraint, and that it deviated from that purpose, and therefore it has to disgorge its profits back into that charity so it can basically pursue that original charitable purpose. So the legal question is going to be, well, is this founding mission an enforceable charitable trust? We'll find out. Like I say, I think this is going to be a tough case for Elon, but we'll see. Now, the other little aspect of this that's kind of interesting is the structural tension. And again, this is where the AI aspect of this kind of turns a lot of the stuff on its head. Sort of like the laws of physics breaking down under enormous pressure. That's what we have with AI. And what I mean by that is that unlike pretty much any other nonprofit spinoff I've ever seen in my life, AI development, it requires massive capital. It expects, you anticipate, huge returns. And you're going to have some economic participation, of course, by individual parties to do that. So what I'm trying to say is that in AI, a nonprofit model probably can't support the scale of AI development. So the court's going to have to decide, okay, well, where's that legal boundary between the necessary evolution of AI and the impermissible mission drift? The other aspect of this that I'm going to keep an eye on is there's a really interesting theory that came out of this, and I talked about this about a year ago. So when this first came up, is Elon made an argument that if a court allows a nonprofit, fund it with these essentially after-tax contributions, what does he mean by that? People get deductions, charitable contribution deductions for amount contributed to 501c3 charities. Now, but they don't get any equity in return. So you're just making a contribution. And he's saying this is an end run around our entire system, because if you allow someone to make a charitable contribution to a charity, get a big deduction, and then that charity turns around and uses the asset derived from that contribution to create a for-profit asset, well, you've kind of reimagined the entire model, because now we've got tax advantage capital funding private investor owned entities. And you can just imagine all the mischief we could get into through that. Now, I want to pause here and just tell you a side note. There is a whole industry that has evolved over the last few years, and I've been involved in these, where we have we have for-profit entities that are receiving mission-driven funds. So that happens. And it is a way for companies to raise non-dilutive capital when they're not only trying to do well, but they're trying to do good. In other words, I do a lot of work with oncology tech startups, and I know of several cancer tech startups that because they're solving a big problem that is of extreme, enormous interest to some nonprofits, they get grants. Okay. They don't give equity, they just get the grant. On the other hand, they also, because there's potential upside, they take investor money as well, or they have owners of the entity. So we've kind of seen that clear distinction between nonprofit mission-driven capital and investor capital erode slightly over the years, just because, and especially true with public benefit corporations. But that was just an aside. The real reason this matters for nonprofits is for two reasons. Number one, if Elon prevails on this charitable trust theory, we're all going to have to maybe rethink the issue of how much donors have leverage over nonprofits, especially when there's this anticipation as to what the nonprofit's going to do with their money and what they won't do. We're probably going to see a lot greater scrutiny when we see a nonprofit spin off a for-profit arm over control, allocation, independence, governance. And this is going to be super relevant to biotech, universities, climate tech, and especially AI. And it's going to maybe cause us all to think a little bit about how much a nonprofit can evolve before it becomes something else. Now, what does that mean as a practical matter? And regardless of how this case turns out, how's that going to change how I do business, right? And how I do law and how I set these structures up? Well, number one, I think I'm probably going to be much more clear about the limits or lack of limits of the nonprofit's flexibility. We might build that right into some of the organizational documents. Secondly, and was always true, document everything, have good records, and understand what you're doing. And I guess thirdly, we'll probably think a little bit about what the risks are if we find another nonprofit that scales quite this much as a result of their for-profit spinoff. So let's stay tuned. We'll, watch this case. I'm going to be keeping an eye on it. I have an idea how it's going to turn out, but I don't want to say because I might be wrong. That happened, I think, once before. So we'll keep an eye on it, and I'll keep talking about it. And when we do get a decision, I'll be back to tell you what I think it means. Thanks. This is Roger Royce with the 10,000 Startups Podcast.